Hello. Luckily, I'm really loud. So please take your seats. We're going to get started because it's a little bit late. I apologize. Welcome to Blank Rome and welcome to Ohio, Pennsylvania's Training for Unaccompanied Minors. My name is Catherine Miller-Wilson. I believe I have spoken with each and every one of you by email. So it's really nice to see your faces. Oh, okay. We are hopeful that coffee is on the way, so I apologize for those who are in desperate need. But we are going to get started shortly. So Elizabeth Yeager is the head of the Youth Advocacy Program in Ohio, Pennsylvania. She's really running the substantive part of this training, and so I'm going to turn things over to her in just a minute. I have two business things I want to tell you. In your packet of handouts, you should see a CLE sheet, so those of you that want credit, you'll fill that out, you'll mail it in. You also should see a yellow paper. That's a list of volunteer interpreters. To my knowledge, they are not certified, although some of them may be, but most of them are native speakers, and they have agreed to help those of you who need the help on the cases that you take for HIAS. So keep that list handy. And the last bit of business, I just wanted to let you know that we will be making an effort to try to team those of you that need and want teams with family law attorneys so that we can refer cases to a team, which will make it easier for you and easier for the children. Some of you may have already formed a team, and some of you may already be taking a case, from start to finish and won't need a team. So I'm going to be in touch with you by email in the next couple of weeks to find out which of those categories you're in. If you need a team, if you have a team, or if you don't need one at all because you're going to do the whole case. And once I have those answers, I'll set the teams up and I will email them out. Okay? Any questions?
Do you have a Wi-Fi password?
Wi-Fi password. Sorry, is Crystal here?
No, I think she'll be here soon.
Okay, so we'll, as soon as I know what she looks like, as soon as she walks in, I'll just kind of interrupt you briefly to get the Wi-Fi password.
Could I make an announcement about another opportunity?
Oh, yes.
Okay, this is an opportunity. I'm still wearing my mask back, so that's how important it is. This is an opportunity for our AILA members. There's another crisis brewing, not just with the kids, but with families. Most of them are single moms in the shelters. And Valentine Brown and I are co-chair of the AILA Pro Bono Committee. That's one of the hats I wear. And we're asking immigration lawyers to participate in an intake day. It's not a one-off, October 10th. And we're asking if you want to do it to fill out these sheets. And there are other opportunities to participate. The families are getting deported very quickly. They have no access to counsel. They cannot afford counsel. So if you're interested, please sign up for a one-off, since it might take us a while to get you a juvenile case. Or you could do both, which is really great. So these sheets are being passed around with a little more of an explanation of all the opportunities to work in a family shelter. And we're just piggybacking off this wonderful group. And we'll do other outreach through the AILA listserv. So this does require a seasoned immigration attorney at this point. So thank you very much, and that is my announcement.
And then I'm just going to go through real quick one last little housekeeping thing. Also in the packets in front of you, you should see an evaluation form. So we would love it if you could fill that out after you're done for the day and let us know what you thought of the training or any suggestions or thoughts that you have. If you're only staying for the morning session, then remember to leave that with us before you leave. And so just real quick to run, before I run through the agenda, first of all.
Crystal, is there a Wi-Fi password?
Just give him.
Excellent.
Okay. So a big thank you to Kathy for putting together all the logistics on HIAS's end. And also, of course, to Blank Rome for providing us with this fantastic space. And lunch and Wi-Fi, apparently. So what we're going to talk about today, and we'll kind of have to try to run through this quickly because we're already a little bit late. Justin's going to first give us a little bit of background on unaccompanied children and the immigration system. We're going to talk about immigration court procedures, generally for those of us that don't usually practice in immigration court. And then we'll talk about special immigrant juvenile status in particular, probably spend most of the time on that. depending on how much time we have left, we're going to run through at least quickly some other forms of relief commonly available to juveniles and other issues that we might deal with as immigration attorneys. We'll have a break for lunch at 12, from 12 to 1 for lunch networking. Maybe some of you can formulate your teams for teaming up cases. And then after that, we've got another panel of presenters who are going to talk about representation in family court. So, Justin, do you have a Wi-Fi password?
Yeah, I'll read that one out.
Yeah, go for it.
Thanks. Okay, so the Wi-Fi for here, the username, blank Rome, all run together, lowercase. And the password is Jazz Festival, 2014, all run together. I don't know if it makes a difference, but the J and the F in Jazz Festival are capitalized.
It does.
Jazz Festival.
2014. Jazz Festival, 2014. Okay, so my name is Justin Mixon, and I'm the immigrant youth staff attorney. I meet with the kids at the shelter, and I interview them and sometimes represent them when they stay in Pennsylvania. I'm going to give you a little background on the kids and where they're coming from, how they get here, a few things. I'm going to try to do it very quickly and loudly, although I guess I'm being amplified a little bit here.
Yeah.
So, yeah, I go to the main shelter once or twice a week, and we screen the kids for legal claims so that when they reunite with their family members and go to another state, we can refer the cases appropriately. And then the ones who stay and go into long-term foster care because they don't have parents or family members they can reunite with, I take some of their cases to family court and immigration court in the counties usually. So we could, yeah, unaccompanied child. All right. So we're going to use, if you're in AILA, I'm sure you're familiar with all the acronyms that we love to throw around. In this kind of work, there's lots of acronyms. One of the ones you'll hear is UAC. The children are classified as UAC if they have unaccompanied alien child, if they have no lawful immigration status, and no parent or legal guardian in the United States that can take care of them and provide custody. Now, if they arrive at the border without parents, they're UACs, even if later on they get reunited with their parents 2-4 weeks later, they're still, for most purposes, considered UACs. There are some rare cases where a child is here in the United States with their parents undocumented and they end up in the child welfare system after living here for several years. So but those are very rare. Most of the cases we're talking about are the kids who arrive at the border without their parents, but they're not coming up on their own. You can imagine a 5-year-old doesn't get here completely on their own. They travel with siblings, aunts, uncles, grandparents. Most of them have a smuggler that rides the bus with them through Mexico that they call guia, which means guide. So just to give you some background there, there are thousands of kids crossing the border without their parents, and it's, as you know from the news, it's increased dramatically this year, but it has been a steady increase over 3 or 4 years. This year, they've already seen more than 60,000 children without their parents. In Pennsylvania, just this calendar year, 462 kids have been placed with their relatives, and that's a dramatic increase, and that's why we need pro bono attorneys to help. That's a lot of kids for Pennsylvania, but it's not the flood that you might be thinking of in the news. Like, just to give you an example, in the same period of time in Texas, there were 5,000 kids placed just this calendar year. So on the next slide, you can see how the numbers have increased over the last few years. And we're talking about what is sometimes called the Northern Triangle of Central America: Guatemala, Honduras, and El Salvador. And all 3 of those countries have seen dramatic increases in the number of kids coming. And I'm going to go to the next one first. This graph has a very similar shape to the last graph you saw, but this graph counts the number of homicides in Honduras, which leads the world right now in its murder rate, higher than Afghanistan. Number of homicides per 100,000 people, and you can see this graph tracks very similar to the number of kids crossing the border. They're not just coming to the United States, they're going to Costa Rica, sometimes Nicaragua, they're sometimes Mexico. They're fleeing gang violence. And, lest the news get this issue wrong, which they frequently do, it really is caused by the epidemic of gang violence in Central America. In many places, the gangs are more powerful than the police, or they may be affiliated with the police. And they're targeting children specifically for murders, assaults, gang recruitment. We interview a lot of kids who talk about at their school, the gang members will be there when they leave school, and they're scared to go to and from school because there's forced gang recruitment, there's assaults, kidnappings. The kids know about other people in their communities that have been disappeared, kidnapped, assaulted. And there are a lot of rapes of girls. We interview girls at the shelter who have faced this. It's an epidemic. There's also an ongoing epidemic at the same time, not just of the gang violence, but domestic violence and family violence, the child abuse. And they're actually kind of connected because the same governments that can't control gang violence are the same governments that can't effectively provide a way for women and children to be safe from domestic violence. And so we see a lot of that too. Child abuse is rampant, and we get those cases, the children coming to the shelter. There's really no functional child welfare system in these three countries, so you can imagine there's no agency that's going to protect them if there's an abusive family situation. Just to give you one example, a client that I have, I'll call her Claudia. So she came in August, crossed the border in August. Until she was 7 years old, she lived with both parents, and then her father kind of abandoned the family, and she stayed with her mother and her siblings and faced really daily vicious attacks from her mother. Her mother's very abusive and alcoholic. And then Claudia was molested by her mother's boyfriend when she was 13. Then when she was 14, her mother left to work in another town and left her to take care of her siblings. The poverty and the violence, it's all wrapped up together here. And the gangs and the other criminals in her town, which is one of the most dangerous towns in Guatemala, they knew she was living alone. So she immediately becomes a target. She had a gang that tried to kidnap her, to force her to be their prostitute. She got involved with an abusive boyfriend. She's pregnant. She made the decision finally that she wouldn't survive in this scenario, and she came to the United States. And anyways, and we're trying to succeed in her case right now. Just a little background on the legal situation for the kids. I don't know if you've heard in the news, the children who aren't from Mexico and Canada get a little bit different treatment. Liz, can you go
I'm sorry.
no, it's okay. That one, yeah, great. So the reason they get treated a little bit differently, the Central American kids get treated differently from Mexican and Canadian kids, is that the result of, there were bad conditions at INS. I'm sure you remember INS. INS detention facilities for kids at the border. Those facilities just didn't provide adequate, healthcare, education, all the things that the kids needed, and they were more like a criminal, detention style facility. And so, as a result of lawsuits and a change in the law in 2008, they passed the second version of the Trafficking Victims Protection Reauthorization Act. The reason you might have heard of TVPRA is that Congress almost repealed the important part of that. Getting interviewed by removal, deported quickly without having their day in court. Now they are held by Department of Health and Human Services, their Office of Refugee Resettlement. So the kids aren't in ICE custody. Well, they're under the auspices of ICE, but they're held by Office of Refugee Resettlement, which is more like a child welfare organization. And so the kids get better care. They're at facilities that are really equipped to handle their education and medicine. And they get their day in court. Instead of expedited removal, they get to stay in the United States and either in a facility or reunited with their parents while they wait for their hearings in removal proceedings. And you might be surprised, most of the kids do show up to removal proceedings after they're reunited with their parents, regardless of their the parents' immigration status. The kids do show up. They stay in these proceedings. So it's the Office of Refugee Resettlement that has the children at first. The shelter I go to is through a contractor called Vera, which manages all these shelters around the country for Office of Refugee Resettlement. It's those shelters have to place the children as quickly as possible with their parents or a family member or a family friend. And the map really is a little out of date. There's shelters all over the country, the map that was up there just a second ago. There's shelters all over the country now because Homeland Security is overwhelmed at the border with the number of kids, and the kids don't get put in Pennsylvania because they have a connection to Pennsylvania. They're really just put here because there's a need for bed space. At the border, the kids cross the border, they're very quickly just sent wherever there's bed space. And then, so a child might cross the border of Texas, be in Bethlehem for 2 to 3 weeks, and then go back to Houston to live with their parents while they wait for removal proceedings. The children are only allowed to spend 72 hours at the most at these shelters that are at the border. You've probably seen them in the news, the kids sleeping on the floor in the big concrete room. They call them hieleras because they have too much air conditioning. It's like a freezer in there. The kids talk about it when they get here. So those facilities, they're not allowed to keep them for very long. They have to send them to one of these shelters as quickly as possible. And then we go to the shelters, just like other organizations around the country that have contracted with Vera and the Office of Refugee Resettlement to provide Know Your Rights trainings for the kids so they get a basic orientation when they first get here, screen them individually. We interview every child, almost every child, at the shelter and learn about their legal claims. And then for the ones that stay in Pennsylvania, we really need help matching them with pro bono attorneys. I think that's it. Thank you for listening. Oh yeah, I'm going to run the slides.
So as Justin said, we're kind of working in various angles of this system, what with these shelters all around the country and kids getting moved back and forth, and then some of them are in the shelters here and get sent somewhere else. Some of them are coming to Pennsylvania to live here with relatives, being released from different shelters. At the end of the day, what we're trying to work really hard on doing is create some kind of a functioning system for getting pro bono representation for these kids. So the kids that we're talking about here in Pennsylvania that need legal services, where we're hoping to involve all of you, are for the most part not children who are at these shelters, but who have come through this ORR shelter system. There's been a sponsor, meaning a parent or an aunt or an uncle or someone else who's been identified as being able to care for them. And now here they are in Pennsylvania, living with this person who they may not have seen in many years, having to show up in immigration court. And of course, as many of you know, there's no such thing as public defenders in immigration court. Many of you probably have been in there on juvenile docket days and seen, I saw a child who must have been about 2 or 3 years old in somebody's arms. That child doesn't have a lawyer, or 14-year-old kids expected to represent themselves unless they can find legal counsel. So can I just get a quick show of hands? How many of you regularly practice in immigration court? So we have a bunch of AILA people here. Some of us might be a little new to this, but so I just want to go through kind of the basics of what immigration court is and kind of how it functions. So first of all, immigration court, this is where the immigration judge is tasked with determining whether the respondent, in this case a child, will be ordered deported from the United States or will be permitted to stay if they're granted some form of relief that exists under immigration law. So immigration court, kind of a less formal setting, I think, than some other courts that you may practice in. As far as, obviously we have the immigration judge. The acronym that we use for the government attorney who's representing ICE is the TA, or trial attorney. There are interpreters in immigration court that are present always, that are provided, that speak Spanish. If your client speaks another language, then you may have to coordinate that with the court ahead of time. But usually what you would be appearing on, at least in these cases, if it's a special immigrant juvenile status case, would be a master calendar hearing, which is fairly quick, and you are speaking pretty much entirely on behalf of your client. They're not being asked to provide testimony, so usually you're not really using the interpreter for much. You can request to have your client's appearance waived in these juvenile cases, and the judge will usually grant that. So say you appear on your first case with the child present, you can ask the court to waive the child's appearance for the next court date, assuming that they're in school, and Judge Morley seems like he'll usually grant that. If you're appearing in immigration court for the first time, you enter your appearance. This is a new development this past year, where anyone who is going to be appearing in immigration court has to register with EOIR. EOIR is the Executive Office of Immigration Review, which oversees the immigration courts. And there's a process online for doing that. You register yourself into the system, and then you're permitted to appear in immigration court going forward. And so the procedures of immigration court governed by the immigration court practice manual, which you can access online. So in immigration court, we have two kinds of hearings. Number one is a master calendar hearing, and number two is an individual or merits hearing. For most of these cases, if you're handling a special immigrant juvenile status case, you will never find yourself at this individual or merits hearing stage. And we'll get into why that is when we talk about SIJ cases in particular. But basically, your case would get terminated in order for USCIS, which is a different immigration body, to decide the case rather than the immigration judge. So where you would find yourself going would be to these master calendar hearings. This is basically a status hearing. And so this is where, at the first master calendar hearing, or the first where you're prepared to go forward with the pleadings, the judge will take pleadings on the case, meaning how do you answer to the charges against your client. You would designate or decline. The judge will ask, do you wish to designate a country for your client to be removed to in the event that they are ordered removed from the United States? Usually we would decline to designate because in the event that you're alternatively considering pursuing asylum for your client in the event that SIJ status is not granted, you don't want to be telling the judge, yes, my client would like to return to Honduras. You want to make sure to say, no, we decline to designate. And then usually the government attorney would designate that country anyway. You're going to, after the judge conducts the pleadings, you have to identify all potential forms of relief that you might be seeking for your client. And you can say, we're primarily pursuing SIJ, but in the alternative, asylum or whatever it may be. And then at the end of that first hearing, the judge will give you a continuance to come back. During that time, you're working on preparing the case. In an SIJ case, you're working on doing the family court part of it. And then, that's happening while your case is still pending in immigration court, and you're requesting continuances until you've completed the family court process. Want to hit the slide? Yeah. Thanks. So this is a new development in Philadelphia Immigration Court where we have a juvenile docket. And this is something that has been started, I think, in probably most of the immigration courts across the country. At first, it was in the bigger cities where they saw a lot of juveniles. Philadelphia is now getting to be one of those cities where we have a lot of juveniles. So Judge Morley is solely responsible for handling juvenile cases. We're pretty happy about that because he seems to be very protective of juvenile due process rights in particular, and has been pretty friendly to attorneys and to juveniles, kind of going through this new process. So those happen twice a month, morning and afternoon. I think lately there's about 50 kids a day. And these cases are considered priority cases. They're designated as priority cases by ICE when they're filed with the immigration court. We've maybe heard around the country this phrase, rocket dockets. There's been news articles saying that, for example, in New York, these kids, the juveniles, are getting put on these rocket dockets, meaning they're scheduled really, really quickly for court, and then they're getting pushed through really fast, and nobody's given any time to actually prepare a case. In Philadelphia, thankfully, what we've been told by Judge Morley is that the cases are scheduled. There's a priority in which they have to schedule them for their first appearance in immigration court within 21 days of the case being filed with the court, which is not actually that much faster than the typical time in Philadelphia anyway. After that first hearing within 21 days, the judge is going to grant continuances kind of in the same manner in which he would in any other case. So thankfully, these are actually not getting pushed through really, really quickly. It seems like in other courts around the country, judges are taking a different view of that. Anytime a juvenile goes on their own to court, so it's pretty common for a juvenile to not have a lawyer yet for their first hearing, especially if that hearing happens within 21 days of their case getting to Philadelphia. What happens in that case? The juvenile will appear by themselves. Relatives, parents, guardians can go with them. They're not required to. We usually tell people that, it's fine to go. Nobody's going to be checking their immigration status and detaining them if they don't have papers, which is something that people are often afraid of. And if they show up without a lawyer, the judge will give them time to go and find one. Right now, about 5 to 6 months usually is when someone would expect their next hearing. So the way that a case gets started in immigration court is by filing this. So ICE files this notice to appear, which is a document that's generated after the individual is detained. In this case, while the child is at the border in Border Patrol custody. The NTA sets forth is the charge of removability. So under what statute is this individual charged with being removable from the United States? In pretty much all of these cases involving juveniles that just cross the border, it's going to be this 212A6, A1 or A2 that says that you are charged with having entered the U.S. without documents, basically. And if that's true, you're deportable. The NTA will set forth the factual allegations to support that. So you entered the country on X date, you're not a citizen of this country, you are a citizen of this other country, you do not have permission to be in the United States. If all of those things are true, then your client is deportable, and then the next question after that is what form of relief are they going to pursue to allow them to stay in the United States despite the fact that this is true. So when you're at the first master calendar hearing and the judge is asking you how do you plead to these charges in the NTA, people have different ways of doing it. Typically in my office, we'll concede to the charges if it's we know that it's true. And then, set forth, explain what kind of relief we're going to pursue. If you were to deny these allegations, then the ICE attorney would file additional documentation with the judge in support of their allegations. And the judge would either sustain or not. So we have an interesting issue that comes up with regard to service of the NTA in a juvenile case. So obviously when this NTA is served with the court, ICE has to serve it also on the respondent. So what happens when the respondent is this 12-year-old kid who's in some ORR shelter in the middle of Texas with no parents around? Are they really expected to know what that means and to know that they have the responsibility to show up in court? This is the requirement for service on juveniles under age 14 specifically is set forth in the federal regulations. And what it says is that whenever possible, with the case of a child that young, the government should be serving the NTA on a parent, guardian, near relative. What we see a lot of times is we have these NTAs and the person that it's served on is the guy who runs the ORR shelter. And sometimes there's supposed to be a place where the person who receives it signs. Sometimes nobody's even signed it, but whoever did the serving will write or stamp served on conservator, which is the Texas word for guardian or the person in charge of the shelter or something like that. So with this issue in Philadelphia, Judge Morley has taken the position, which is a favorable one to us and to our clients, that that is not proper service. That at least in the case of a child this young, service must be effected on the parent or a guardian, especially when ICE knows that information, which they always do because that's who the child is ultimately released to. So we had a couple of cases kind of early on where the judge agreed to terminate proceedings because this was not proper service. What's happening now is that, ICE has caught on to this and they, which is a good thing, they've been serving the NTAs on the children's relatives in Pennsylvania. So oftentimes we'll see a case where a child was released from a shelter to Pennsylvania. The NTA had been served on the shelter people and filed with the court. Then what the ICE attorney will do again is reserve it on the parents here. they usually seem to try to do that before the first hearing and then show up to the hearing with that proof of service, and then the case goes forward. Or the attorney will ask the judge for a continuance to effect proper service. If that doesn't happen, if you think that there's an issue with service, you can certainly make a motion to terminate. It might be a strategy that you want to pursue. I think as a practical matter, it seems like ICE will find a way to complete service and the judge will allow them time to do that, but just to kind of put that issue in your minds. Okay. So,
excuse me.
Yeah.
On that one
Yeah.
point, I mean, what's the recommendation? Should you pursue it if it exists, or is it just other than buying you a little more time, does it really serve much of a purpose?
Yeah, I mean, it might buy you a little more time. So, for example, we had a case where I made a motion to terminate in court because there was not proper service. The judge said, "Okay, I'm terminating proceedings." A few weeks later, I turned around and filed a new NTA and filed a motion to reopen, and then the judge granted it. So, in that case, I mean, it really didn't do much other than give us a little bit of time. Maybe you would have a case where ICE, for whatever reason, it would fall off their radar and they wouldn't reserve your client and motion to reopen, but who knows? So, special immigrant juvenile status is what we're mainly talking about today because this is the main form of relief that we see.
Can I ask one thing? I'm one of those people that knows nothing about immigration.
Oh yeah, no, sure, please go ahead.
With regard, it says in the notes here that the hearings are open. I mean, after we do this training, would it be recommended? Would we be able to go over if they are open? Would we be able to go over and spend an hour or two watching actually what goes on?
Oh yeah, absolutely. That's a great idea. So all of these.
Where is it?
It's at 900 Market Street. Up on the, yeah, exactly. The next federal building up on the 5th floor. Yeah. So, and the juvenile hearings that are on Thursday. Well, that's a good question. I mean, because they are still usually open hearings. We'll talk. Yeah, we'll talk to the court and see. Certainly on non-juvenile days, it's not a problem for anybody to go up and observe. The juvenile, they might have some special issues about.
That's what I was wondering with the juvenile waiting, right?
Sure. Yeah. Go ahead.
So all counties where the children are placed, everything is funneled through Philadelphia? Okay.
Yeah. So Philadelphia Immigration Court has a wide reach in terms of most, this half of Pennsylvania, and even Delaware and parts of Virginia, I think.
Okay.
I have a quick question. UIC children, if they have a parent here in the United States and they are coming, obviously looking for it, but they still come unaccompanied, when they get to the border, they're still qualified in the same manner?
So, I'm sorry, say that again. If they have
I was just looking at the definition of UIC, the unaccompanied alien child. If they come to the border, but it says, and they do not have a parent with them, but it said they don't have a parent with them at the time of arriving at the border, not that, for example, there's a parent or both parents here in the United States and they're just crossing.
So, all that word, UAC or unaccompanied alien child, that doesn't confer any kind of immigration status on anybody. That doesn't get you the ability to stay in the United States or win your case. That's just the kind of word that the government used to refer to these children, and that entitles them as an unaccompanied child to be put in this ORR custody rather than go to an ICE detention center like the Berks Family Shelter, which is not a great place to be. Whether a child who's living with parents would qualify for immigration relief, specifically special immigrant juvenile status, is kind of another question that we're going to address right now. So, any other questions about court or any of that stuff? Okay. So what is special immigrant juvenile status? Basically, this is a protection that exists under the law, which provides a special path to permanent resident status and eventually citizenship to children who have been neglected, abused, or abandoned by one or both of their parents. Justin, you did the slide. Thank you. So, and just a couple of things to kind of remember in the back of your mind as we're talking about what are the requirements under the law. So first of all, there's no length of residency requirement. So we've seen a lot of cases, which are probably not the cases we're going to be referring to you guys, but cases where a child has been living in the U.S. for a long time and is currently in local foster care because they were abused or neglected by whoever was caring for them. And we get referrals for those cases through Philly DHS and the local children and youth agencies. For a long time, those I think were probably the majority of SIJ cases that were filed with USCIS. But there's no requirement for having lived in the U.S. a certain amount of time. These very children who are crossing the border right now can qualify if they otherwise meet the requirements, regardless of whether they're in deportation proceedings or how long they've been here. And it's important to think of this and remember that, this is not a way for people to evade the immigration laws. This is a protection that exists under the law because Congress decided that we should have a protection for children who can't go back to their countries and who can't reunify with their parents or with one of their parents for one of these reasons. One important kind of result of obtaining special immigrant juvenile status for your client, normally, whenever somebody becomes a U.S. citizen through whatever means, they are then entitled under the immigration laws to bring certain relatives over to the U.S. as permanent residents themselves. And an adult who becomes a U.S. citizen can petition to bring their parents. In the case of a special immigrant juvenile, somebody who gets their citizenship through this path can never petition for their own parents. Even if they qualify as a special immigrant juvenile because they were abused or neglected by only one of their parents, they still can't bring the other parent. So an important thing to make sure that your client knows and is aware of when you're pursuing this. Usually this is not going to, if this is the only relief that your client's eligible for, they're probably going to say, okay, well, let's go ahead, because it's not like they're going to get their residency and citizenship through any other means anyway, so it's better than nothing. But just something important for people to be aware of. So I just have up here outlined what are the sources of law where the SIJ law comes from. This is in the INA under the definition section. It has a definition of a special immigrant juvenile. There are regulations that were published but that are now outdated. So the law changed in 2008 with the passage of this Trafficking Victims Protection Act, or TVPRA, of 2008. Previous to that, to qualify for special immigrant juvenile status, a child had to have been deemed eligible for long-term foster care. So that's another reason why, especially back in the olden days, before 2008, really this was a form of relief for kids that were in county foster care in the United States. So this was changed to the current requirement, which is that the child has been abused or neglected or abandoned by one or both of their parents. So with that change in the law, it really broadened this to now be available to more children. So there are regulations that were promulgated after the old law and that have not yet been updated pursuant to the new change in the statute. So if you look at the regs up, parts of it still apply, but parts of it have clearly been become outdated. There's a couple of USCIS memoranda too, particularly the one that from 2009 is kind of the most useful, and an older one that's useful for some purposes, but also a little bit outdated. So I didn't copy and paste the statute because I thought it was easier to just kind of list out the requirements, but here they are. So to qualify to have your your SIJ petition approved by USCIS, the Immigration Service, a child must be under 21 years old at the time they're filing their petition with immigration. They must be unmarried. They must have been declared dependent on a juvenile court or placed under the custody. Oh, that actually should have another line in there. Under the custody of a state agency or individual appointed by the court. So pretend there's another word. This really important word. I don't know how that got left out. My fault entirely. So in Pennsylvania, the real age deadline is not this age 21, but age 18. So we see emergency cases all the time where there's children who are 17 years old going on 18. They might have a really strong SIJ case, but there's no way that they'll qualify unless you can get this family court order done by the time they turn 18. And so what does the family court have to determine? In addition to placing the child under someone's custody or finding them dependent, the family court judge has to determine that reunification with one or both of the child's parents is not viable due to abuse, neglect, abandonment, or a similar basis found under state law. And that similar basis has usually been interpreted to mean, like, some states would have a different word that they use to mean neglect or abandonment. The family court judge also has to determine that it is not in the child's best interest to return to their home country, that it is in their best interest to stay in the United States. This is not written here also, but there should be a statement in the court order that the court retains jurisdiction over the matter. And then finally, there's this kind of weird catch-all requirement at the end that says, oh yeah, and the Immigration Service has to also consent to granting you SIJ status. What does that mean? We'll give it to you if you qualify, and also we want to give it to you? Kind of, that's what it sounds like. Really, what this has been interpreted to mean, I believe in the AAO case law, is that the family court order needs to be, non-frivolous. It needs to have been obtained. It needs to be a bona fide family court order, which should mean that it's based on truth and facts. And the USCIS officer who's adjudicating the case at the end has to have some knowledge of the basis or the reason for the family court order. Supposedly, I mean, this is what's written out in the USCIS memos, is that the officer should have some basis of what was the reason for that family court order and what's behind that family court order. On the other hand, it's also clear in USCIS memoranda that it's not the job of the Immigration Service to go behind the family court order, because the family court is the one that is responsible for making decisions about the child's care and custody and all of that stuff. So the way that we kind of navigate that nuance is that we suggest that it's always best in family court if the family court order contains not just this blanket cut and paste of the statute, but just a quick explanation of the factual basis for those findings. So reunification of the child with a parent is not viable due to abandonment in that the parent has failed to provide care or control for X years or whatever. The reason why we suggest doing that, and we've certainly filed cases where we didn't have all of those details in the court order, and it's been fine, and CIS has approved them. If we didn't have that language in there, the CIS officer could say, we don't have enough information of the basis of this family court order, and they could issue you a request for evidence and ask to see copies of filings that were made to the family court or evidence that was presented to the family court. So you can guard against that. You're preserving a good argument that they can't ask to see those things, which should be, confidential, by just including a little bit more information in the order itself. Does that make sense? Mm-hmm. Okay. So these cases, all of these SIG cases, we've got these two phases. The one that happens in family court, and then the other one that happens with CIS. So we're going to talk in a lot more detail, or our experts on the matter this afternoon are going to talk in a lot more detail about exactly what goes on in family court and how to get that court order with the necessary language. Once we have that, we move on to the phase with USCIS, the immigration authorities. And then that results in, we file the application. If we win, then the child gets a green card. So I just have up here the language, and you have in your some materials that are going to get handed out later today, some that were emailed out to you guys, samples of different family court findings and orders. So this is just one example of what the order should say. So the finding of custody or dependency, and then I have a sample here that's reunification of the minor with her mother is not viable due to her death. With the father is not viable due to persistent neglect in that the father failed to provide care or control. So again, just a little bit of extra detail. And again, also with the finding of the child's best interests. So skipping ahead, assuming that we've had success in family court and that we got this, yeah, go ahead.
Yeah, a question, Liz, and perhaps I'm sure they'll go into this afternoon, but outside of a dependency proceeding, you're probably not going to be usually dealing with someone where both the parents are out of the picture, right? They're placed with a relative, unless it's an aunt or uncle. It's going to be usually the mom or the dad. And so there is a viable parent here.
Yes.
You go to custody court and say, dad's dead or he's abandoned the child, so order the custody and the mother, and is that going to cover?
Yeah, exactly. So going back to what it's the actual language of the statute is reunification with one or both parents is not viable. What USCIS thankfully has agreed with immigration lawyers who have advocated for this notion that you can have a case where the child is living with one of their parents, but where reunification with the other parent is not viable due to abuse, neglect, or abandonment. And so even in a case that we see pretty routinely where the child's living with their mother and the father abandoned them many, many years ago, that should qualify for SIJ. And there's been some bad state court decisions in other states outside of Pennsylvania basically not allowing those to go forward. I don't really think that that's a decision that is properly made by the state court, because it's within the state court's power to make those findings, and then immigration is the one who should decide if they qualify for SIJ, right? But USCIS has made clear this past year, I think just a few months ago, they put out a couple of flyers on SIJ for for like child welfare workers in state courts. And in there, USCIS clearly states that a child who's living with one parent, but where the findings are made regards to the other parent, can qualify. So that's in the materials that we sent around. But we're going to talk this afternoon about like kind of the logistics of making that happen in family court.
That's in the packet.
So there's different materials.
In a one-parent case like that, can death of the second parent count as an abandonment?
That's a really good question. So I actually have the same question for like Stephanie and our family law attorneys that are going to handle the cases this afternoon. We've had cases, yes, where, from my perspective, I'm always handling it on the immigration side. And from my perspective, if we're going to get a family court order that says that the father or mother abandoned the child through death, then sure, we can go ahead and file. And I have had cases where we've gotten a custody or dependency or guardianship order that just says the parents are deceased and doesn't use the magic word abandonment. And we filed those with USCIS too, and those have gotten approved. So those are certainly worth going forward on.
You can do it.
Yeah. I mean, because imagine, if the kind of the purpose of what the statute is, you have a child who has no parents because they're an orphan, then they should be able to qualify. Mm-hmm. Other questions? Okay. So assuming that we were successful in getting the family court order, what do we do now? So in immigration court, you've been filing your continuances while you were pursuing the family court part. In immigration court, for those of us who are new, you can do a written continuance. After you've appeared in person at your first hearing, it's pretty routine to file a written motion for continuance. If you're filing that motion because you filed something in immigration court, keep doing that, in family court, and you're waiting for a hearing, then you want to make sure to include, proof of that. Once you obtain the family court order, you can file a motion to terminate removal proceedings. So terminate means closing removal proceedings. What this does is it allows USCIS, which is the immigration service totally separate from the court, to then adjudicate both your SIJ petition and your permanent resident status or green card application. So for those of us who are new, the forms that you're filing, do you want to skip ahead, Justin? I think I have that on the next slide. So there's two applications that we're filing. So we're applying for special immigrant juvenile status. A grant of special immigrant juvenile status immediately entitles the juvenile to also apply for adjustment of status. So there's a couple of ways that we kind of use that term as immigration lawyers. Adjustment of status to lawful permanent resident. So the child is applying for permanent residence, also known as the green card. And the form that you file for that is the I-485 adjustment of status application. And then there's the I-360 SIJ self-petition. So the easiest thing to do is to terminate removal proceedings, because then you can just file those two things at the same time. And then typically USCIS will adjudicate them together. And then if the I-360 is approved, then at the same time, also the I-485 is approved. If the case were still open in immigration court, then USCIS would be the only one with jurisdiction to decide the I-360, and the immigration judge would be the only one with jurisdiction to decide the I-485. So since that doesn't seem to make a lot much sense, thankfully the court has agreed with us, and our local ICE chief counsel's office hasn't put up much of a fight, that the cases should be terminated once we get the family court order to then allow for filing these two things concurrently. That make sense?
Is this in our materials?
It is, yeah. So this is just a list of what all gets filed. One important note is when you're filing with CIS, typically most immigration applications have a fee associated with them. And for many of them, you can seek a waiver of that fee if your client is under a certain income, under 150% of the poverty guidelines, or has another special financial hardship. In the case of SIJ petitions, there's no fee for the I-360. There is a fee for the I-485. It's $1,000 and some dollars. Most of these juveniles do not have that kind of money, nor do we think it's appropriate to ask for their caregiver to provide that payment to CIS. So CIS will just grant the fee waiver. All you need to do is fill out the fee waiver form, write in where it says explaining your economic hardship, write in a statement that they're applying for SIJ and they were abandoned or neglected or whatever, and then your copy of the family court order serves as the only proof that USCIS needs to grant the fee waiver. You don't need to worry about including proof of the income of the child's guardian or anything like that, which is normally what you would do. They're pretty lax with these and they tend to grant them. Moving on. Thanks.
I have a question.
Yeah.
I wonder if you guys have any experience with, are there any certified civil surgeons that do it? Low Bono or?
Oh, that's a good question too. Yeah, so the other thing on that list that everyone who's applying for permanent resident status needs is this medical exam by a designated civil surgeon, which, for anyone that doesn't know, is a particular medical doctor who's been designated by CIS with this authority to complete this form, assessing the individual's health. That gets put into a sealed envelope that you send in with your application. There's a fee for that always, because this is not something that your primary care doctor can just do. It has to be this special designated civil surgeon, and each of them charges their own fees. We always use Executive Health Service, which is just one that's here in Philly that seems to have the best prices, and also they're good when someone's going to get their medical exam done, they usually have to show ID so that the doctor is verifying what their identity is while they're filling out the forms. That can be a challenge for juveniles because they might not have ID. So this same office, Executive Health Service, has been good with us about stuff like that. But it usually costs around like $200. There's no way to waive that fee because it's just the doctor's office that's charging it, and we haven't found anybody that will do it for free. Yeah, go ahead. Yeah.
You have birth certificate up there. Who
Yeah.
did all that paperwork?
Yeah, so, typically in our experience, most of these clients will have their birth certificate or a copy of it.
Really?
Yeah,
They
yeah.
come across the border with it?
Yeah, sometimes children will travel across the border with it. If not, they're detained at the border, they're put into ORR care, and they're not going to get released until the staff at the shelter can verify who they are and who the relative is that they're going to. So at some point, somebody gets that birth certificate, and by the time they get released to a relative in Pennsylvania, they've got at least a copy of it. Yeah.
Who does the translation?
So and when we're filing that with CIS and sending in the birth certificate, we send in a copy of the birth certificate, not the original. It needs to also have a translation with it. So that's something that just needs to get done. If you guys are working with volunteer interpreters and translators, we would expect that person to help out with that too. So yeah.
Is that staff doing the same thing for parent death certificates? Are they necessary, the death certificates?
I would think that that at the family court stage is when you would want to have that to support the allegation that the parent is deceased. You don't necessarily.
You're not required in family court, at least in Bucks, you're not required, but you, if you have it, that's good. Also in Bucks, we don't require translation of birth certificates. Is the translation required by a certified translator or by anybody who can do a translation?
For immigration, anybody that can do a translation. There's a particular sentence that you have to put at the bottom of it. The translator has to certify that they are competent to translate and that's an accurate translation, but that's it.
Okay.
Other questions? So you put together this packet. Oh, and I was going to say also about the birth certificate. So a lot of times the only birth certificate we have is a copy. Maybe it's like a faxed copy that got sent over to the shelter from a relative in Honduras or something like that. And that's enough. We've never had CIS demand original birth certificates. And the reason for that is because in these SIJ petitions, these juveniles are held to a slightly lower standard in terms of proving their identity to immigration. With a different kind of immigration application, in the typical scenario, you're required to prove your identity. With these SIJ petitions, the child is required to prove their age, for one thing, and they also can't be made to get documents that they just can't get because they're a juvenile and they're vulnerable and whatever findings have been made in family court. And they can't be required to inappropriately have, they can't be required to have contact with an abusive parent in the home country. So if the only way to get this birth certificate and stuff is to have contact with family members, it's not reasonable to expect them to do that. Really, CIS has just been a little bit lenient with us on this. So we send in a copy with the translation, and that's it. If you have an original, then you could bring that with you to your interview with CIS in case they ask to see it, but we usually don't offer that because we don't want them to expect that to show up in every case. Yeah, go ahead.
What, I'm not clear on what percentage of the kids coming over have a human being here to whom they're connected, and how many are headed for foster care?
Most of them have someone here that they'll end up living with.
Otherwise, it's foster care. Okay.
Yeah. So the foster care cases are really very few and far between. Probably the foster care cases are not the ones that we're going to be referring out to you guys, because there's a small number and we handle them in-house.
It's just a conduit to the immigration court.
What's that?
Dependency court, family court, dependency unit in family court becomes a channel to get to immigration.
Well, so dependency court is a necessary step for a child that wants to pursue this in immigration court. They're in immigration court automatically because they've been detained and put into proceedings.
Oh, okay, fine.
Yeah. So you file your application with CIS. The next two things that you're going to have to worry about and that your client's going to have to worry about are just these two steps. Number one is a few weeks later, the client will be scheduled to have a biometrics appointment. So they'll have their fingerprints taken if they're if they're over 14, and they'll have their photo taken, and that's the photo that will show up on their green card if it's granted. And then after that, they'll have an interview with the USCIS officer. So the biometrics fingerprinting appointment, client goes by themselves. They have to bring some ID if they have it, like a school ID. That can be a little bit tricky sometimes if they don't have it because they're too young. Usually, one way or another, the fingerprinting people will figure it out. Sometimes it's best to have a guardian or parent make sure that they're there with them with any other documents or stuff that they might have with their name, or a copy of the court order or school records or something like that if they don't have ID, their birth certificate, for example. But so then after that, the big step is this final interview with USCIS. So you're not going to go with your client to the biometrics appointment, it's just to take their fingerprints, but you are going to go to this interview. This is at the USCIS office over on 30 North 41st Street. It just opened up there last year. Used to be on Callow Hill. And this is where they're going to sit down, your client and you and an interpreter are going to sit down with a USCIS officer who then questions your client. And so at the interview, it's your client who's being interviewed. Even in the case of a young child, they're mainly asking that person questions. You're there in case you need to help provide any information or kind of work anything out, or in case, God forbid, something strange happens. But your client needs to be prepared to answer questions. You will need to bring your own interpreter to this appointment. They will not provide interpreters at USCIS. And so what the officer is going to ask is basically anything on the application forms that you filled out. So have that in mind when you're filling out the forms with your client, and make sure that your client has that in mind too, that these are the kinds of things that are going to get asked, and that you'll want to review with them again ahead of time to make sure that they're able to answer the questions. And it's mainly simple stuff like, what is your name, what is your birth date, what is your address? They'll ask, when did you come to the United States and how did you get to the United States? They might ask some questions about contacts with family in your home country, relatives that you're living with now. Again, the officer shouldn't be kind of diving into the substance of how and when and where this child was abused or neglected or abandoned, because that decision's already been made by the family court judge that has expertise in those things. But what they will do and should do is also screen for any inadmissibility issues. So at the end of the I-485 form, if you're filling it out for the first time, you'll see there's this whole multi-page list of yes and no questions. And some of them are questions where if you check yes, it's a problem because it's a red flag. It means that you might have an issue with being eligible to get your green card. Questions about have you ever been arrested, detained, committed a crime that you weren't arrested for, and stuff like that. The officers might go through every single one of those questions with your client, even though some of them are really kind of strange. But most likely they'll at least ask your client things like, have you ever been arrested? Have you ever committed a crime? Have you ever committed immigration fraud, and some stuff like that. They might ask some questions about kind of what your plans are for the future, kind of be chatty and nice. Some of the officers are chatty and nice. Some of them are like really mean and treat every interview like they're doing an ICE officer conducting an ICE investigation. Yeah, go ahead.
How old are the clients going to be?
So in all of these cases, for the most part, teenagers. So up to 17, going on 18 in an emergency case.
Younger side.
And on the younger side, we've had clients. I was at USCIS with a 9-year-old last week.
Wow.
So if they're really young, the CIS officer might want to, and you might want to offer them to speak with a parent or guardian, whoever the child's caretaker is. If your client is a child and are not going to be really able to answer the questions that are on the forms. Yeah.
Question. You said that one of the questions involved like a detention facility. So if the child at the border is put in a detention facility, even if it's for only a few days before it's released to a family member, when filling out the form, is it a red flag then to check yes and put a supplement answer?
So one of the questions on the form, on the I-45 form, is have you ever been arrested before? We always check off yes to account for having been detained by immigration, and then you would just add a little addendum at the end explaining I was detained by Border Patrol right after I crossed into the U.S. I was put in an ORR shelter, and then I was released to go live with so and so. And that's not something that's going to make them ineligible for the green card, but you do have to answer that question truthfully. And so we're gonna, yeah, go ahead.
In the situation where you have a younger child going in for the interview, any issues if the parent or guardian is undocumented?
Yeah, so that's a good question. So obviously, if you're representing the child, you're representing the child, and that's your client. I think people have kind of done this different ways and advised their clients different ways. I think so. The officer shouldn't be asking into the immigration status of that parent, right? Or guardian or whoever it is. But they could. And you could instruct your client or the person who's being interviewed, to not answer those questions if they don't want to. Sometimes the officers will get into asking questions like, how did you, when they're asking about how the child entered the United States, they might ask, who brought you here, who paid for it. And the reason why that is of interest to an immigration officer is because the act of smuggling someone else into the United States, the person who did the smuggling, that then is a check against them. If they later try to apply for their green card, they are inadmissible because they have engaged in alien smuggling. So the officers might ask the child client those questions. If it's really irrelevant, which I think often it is, that you can tell the child not to answer. The child doesn't have to answer. I don't know whether, and I think there's potentially a risk that if you have the actual adult in there who facilitated the child's entry to the United States, they could be asked that question, and you would need to prepare them for that potential, risk if they are going to go in there. So it's a touchy issue for sure. Yeah, go ahead.
Do Fifth Amendment rights extend to those proceedings, and is there any negative inference if you exercise it?
Oh, that's a good question.
I'm sorry, I couldn't hear the question.
Do Fifth Amendment?
Could you repeat that?
What's that? Yeah, so the question was, do Fifth Amendment rights extend to the situation? I don't think this is I'm not a criminal lawyer, and this is not a case where the person is obviously involved in criminal proceedings. Anybody who, any question somebody they can't force you to answer a question, right? Whether you say, I plead the Fifth, or you say, I don't want to answer, you just don't have to answer. Is it possible that the CIS officer could draw some kind of a negative inference from that? Maybe, probably. Yeah, go ahead, Jeff.
Yeah, just to follow up, they're allowed to draw a negative inference, and you're allowed to exercise those Fifth Amendment rights if you're subject to criminal prosecution for answering it. So I guess if it's a question of smuggling someone in, I'm sure, I don't know what the statute is, but I bet you it's against federal law, and it would be a criminal. It could be potentially criminal.
That's true. And if you're in a situation where you're representing the child, you're clear with your client that you're representing the child. And so perhaps in that situation, if the parent guardian who would be asked to come in and answer those questions had concerns about that, the best thing for them might be to seek advice of other counsel. Yeah. Yeah, go ahead.
Could you get a family friend or someone to answer questions for the child?
Probably. Yeah. And you could certainly, try doing the interview, and if the officer wanted more or needed more and wanted information from somebody else following that interview that you had, they could issue a request for evidence asking for that. Yeah, go ahead.
Bringing your own interpreter, would that be those people that?
Yeah. So, any attorney who's bringing their client to one of these interviews, you've got to bring your own interpreter. So we would expect that you guys would work with the volunteers who've signed up and hopefully be able to find somebody that way. Sure. Yeah.
Is there anything wrong with the attorney being the interpreter?
Yeah, the attorney can't be the interpreter at the same time. You could have another attorney do it. Justin and I will go together and each interpret for each other's cases and stuff like that. If you and the thing also, that actually is a good point, because these SIJ interviews tend to get scheduled in a bundle on the same day. So if I filed a bunch of them, I often have all 5 at the same day for interviews, but maybe some of us will be there on the same day. Yeah.
If the pro bono attorney is using his or her personal computer that it may or may not be encrypted, are there some sort of privacy issues in communications or that we need to be concerned about?
You mean your computer for what purpose?
Drafting a motion. For example, any kind of court petitions or...
I mean, we do all of our work in my office on computers that I don't think are subject to any kind of fancy encryption. I've seen different offices use that kind of stuff when sending emails, but I don't think that there's anything kind of particular to these cases that doesn't apply to any other legal case you might be working on. Okay. Anything else? All right. So say you've gone to your interview, everything went well, and your case gets approved. What that means is that when the I-360 is approved, the child is granted special immigrant juvenile status. So let's say, for whatever reason you did the I-360 by itself, they have the special immigrant juvenile status. That alone doesn't really get them anything other than the ability to also be eligible to apply for their green card. So normally in these cases, if you filed both together, probably both, if they're going to get approved, would get approved at the same time. And then your client, from the date that the decision is made, they're a lawful permanent resident. 5 years down the road, they're able to apply for citizenship. They can travel outside of the country for shorter periods of time. Yeah, go ahead.
Is there any reason that you would file them separately, or is there a deadline if you did file them separately to then apply for the adjustment?
So if you did file them separately, the deadline to apply for adjustment would be before the child turns 21 years old. The only reason that we have filed them separately is, number one, in cases where for whatever reason the court would not terminate removal proceedings. And so we had to file the I-360 by itself because USCIS doesn't have jurisdiction over the I-45 if the case is still pending in court. So once we then got the I-360 approved, we could terminate removal proceedings and then file the I-45 with USCIS. And then the only other scenario where we would do that is in these federal foster care cases, because the child's eligibility for foster care depends on having an open removal case. So we need to keep their case open in court for a certain period of time. I don't think that's going to be an issue that most of you are dealing with. So in the case of a child who's not in federal custody, is living with a relative, usually the best thing to do is terminate in court and then file both of them together. Yeah.
Once the green card is issued, which is actually a white card, not green, but and they cannot, even when they become adults, they cannot petition a relative.
So there's different categories of relatives that a person who's a U.S. citizen can petition for. One is your parents. These children can never petition for their parents. Another is a spouse or a fiance. Let's say they got married to someone outside of the country, potentially, just subject to the normal immigration procedures. And then another thing is siblings. U.S. citizens can petition for siblings. There's a really, really long waiting period. I think it's unclear whether that also is prohibited for people who get SIJ status because of their relationship with that sibling has to do with the relationship to the parent. Yeah. Go ahead.
Just a question: if the status is based on abandonment by one parent, are they prohibited from?
Exactly. Either. Yeah, they're prohibited from petitioning for either parent ever. And so another thing that I kind of want to run through right now, kind of quickly, is this idea of grounds of inadmissibility. So again, when we're talking about the questions that show up on the I-485 form where USCIS is screening for inadmissibility issues, this is this concept under immigration law where anyone who's applying for admission to the United States or applying for permanent residency while they're in the United States has to prove that they are admissible. In other words, that they don't fall under these certain categories of people who are not eligible for status in the U.S. There are certain grounds of inadmissibility, and some of those grounds, fortunately, are automatically waived for special immigrant juveniles. Some are not automatically waived, but are waivable if you can file a waiver request and get that approved, and some of them cannot be waived. So we'll just go through really quick the next slide. So grounds of inadmissibility that typically apply for people applying for their green cards, but that don't apply to special immigrant juveniles. So EWI, meaning entering the U.S. without inspection, typically having crossed the border without documents will prohibit you from getting a green card in most circumstances. It just doesn't apply for these kids, so it's not an issue. Similarly, misrepresentation, so having committed fraud or misrepresentation to get an immigration benefit is another inadmissibility ground. Let's say you had a client who didn't come into the U.S. just by crossing without papers, but had a fake visa. That's waived. So that's still not an issue because they're a juvenile and it doesn't apply. Entering the U.S. as a stowaway on a ship also. Believe it or not, I have a client from Nigeria who came in as a stowaway and we're filing SIJ for him. And public charge is another one. So in family-based immigration cases, the immigrating person needs to show that they won't end up as a public charge needing public benefits. That also doesn't apply to these kids. The ones that are waivable that you might sometimes see is if a child has a history of engaging in prostitution or smuggling other people across the border or certain other kinds of immigration-related violations or health concerns. So the formal procedure for seeking this waiver is that we file this I-601 form and you submit evidence that the waiver is justified for humanitarian purposes and it's this discretionary decision by the immigration officer. I think that we've, for the most part, actually kind of often not filed the formal waiver application form, but submitted some evidence, and usually that's been to the satisfaction of the immigration officers here at the Philly office. And so then there are grounds of inadmissibility that unfortunately are not waived and not waivable in these cases. And so these are mainly criminal issues. So those of us who handle immigration cases outside of the juvenile world confront these issues a lot with adult clients that might have criminal convictions. You're probably not going to see too many unaccompanied juveniles that have adult criminal convictions because they wouldn't have had much time to commit too many crimes before you got to working with them. But you might see cases, one issue that we have seen with children coming from these horrible places in Central America where there's gang violence and forced gang recruitment and all kinds of bad stuff happening is children who are forced to engage in drug trafficking. And that last one is interesting because typically what will trigger this inadmissibility issue or, with regard to crimes is a criminal conviction. But there's a separate inadmissibility ground for someone for whom the government has reason to believe that they have engaged in drug trafficking. And you don't need a criminal conviction to trigger that inadmissibility ground. So it could be a kind of a tricky situation if you have a client, even if they were kind of coerced into doing it, who had participated in drug trafficking or drug smuggling. When we're talking about criminal inadmissibility grounds, note that juvenile delinquency adjudications do not fall under this. So for immigration purposes, having been adjudicated delinquent does not count as a criminal conviction. However, it is going to be something that perhaps the USCIS officer could take into consideration because at the end of the day, any green card application, adjustment application is a discretionary decision. So in the case of someone who had committed a very, very serious juvenile delinquency offense, it's possible that you could get denied on that ground. And so what happens then when a case gets denied by the USCIS officer, depending, but oftentimes they're referred back to immigration court for removal proceedings. So if we're talking about these cases, again, I don't think that that the criminal issues are things that you guys are going to be seeing a whole lot of. And in the end, these are considerations that in an affirmative case where the child's not already subject to potential deportation, you're going to weigh very carefully whether it's a good idea to go forward or not. If your client is in removal proceedings anyway, usually it's, why wouldn't you just try? Yeah, go ahead.
And these are related to criminal convictions that occurred in the United States.
Or
not
anywhere.
Anywhere.
Yeah. So, and when you're asked that question on the application form, it's have you been arrested, detained? That means anywhere. And so and also it means, detained by immigration in the U.S., detained by immigration in Mexico. So your client tried to travel up through Mexico, got detained and deported back to El Salvador, and then tried again. That's all stuff that needs to get disclosed. Yeah.
If they were in a gang, how do you go by answering the terrorist activity question? Or
that's a good question. I have not filed one of these for somebody who was in a gang.
Okay.
I don't know if anybody else here has. Yeah, go ahead.
Is the permanent bar applicable to minors? I know you said in an iwi and unlawful.
Yeah. Oh, you mean for multiple?
For multiple,
entries?
for multiple.
No. Also, I think it's automatically waived if I'm.
They can't accrue unlawful presence until they turn 18.
Right, that's true. Yeah. So the kind of entry immigration violation stuff, don't worry about. Yeah, go ahead.
Is that including false claims to U.S. citizenship?
I believe so. So in the packet of materials that got sent out yesterday, there's a 2009 USCIS memo that lists all of this information outright, and that would be in there. And its U.S. citizenship claim is either waived or waivable. In other words, yeah. And so, real quick, I think we kind of talked about this already, but age, identity issues, you're probably going to have a birth certificate for your client. If you don't, just know that there are kind of creative ways that you can present other evidence of your client's identity and age if it comes to that. I'm going to move forward, Justin, real quick. Okay, so we don't have any time really, 6 minutes, but I'm just going to let you know, first of all, that there are some slides here with some other information. And just to put on your radar, we're going to be trying to refer you these SIJ cases because that's kind of the most common form of relief that we see. But obviously, you're going to want to bear in mind and obviously be screening your own clients if you're representing them in immigration matters for any other potential forms of relief that they might qualify for. So let's say we have children in immigration court and removal proceedings. They're not pursuing SIJ. What else is there? So number one is asylum, which is complicated right now for a whole lot of reasons. But so basically, asylum is a protection that's available for people in the U.S. who fear persecution in their home countries, who meet the definition of a refugee. The challenges that we see, if you could hit the next slide, Justin, for these cases involving juveniles is that, overwhelmingly, we're talking to children who are afraid to return to their country because their countries are a complete mess and their governments are not able to protect them from societal violence, gang violence. In most of the cases that we see, unfortunately, it's very hard to make out the argument that the kind of potential harm that your client will face kind of meets the specific requirements for asylum, namely that they're being potentially persecuted for one of the protected reasons because they're a member of a particular social group or whatever it may be. Of course, there's a difference between a winnable asylum case and a frivolous asylum case, and so if there's no other option available, then we typically counsel all of these people, if you are afraid to return to your country because of some bad thing there that you think is going to happen to you, there's a way that you can craft an argument to at least try. But one of the reasons that we see, sometimes people would think, well, why wouldn't you apply for asylum if you're coming to the U.S. and there's gangs in your country and you're afraid of them? And the answer is that many of these gang-related cases are just not winnable under current law. But there are, fortunately, some special asylum procedures that will help in some ways these juvenile cases, unaccompanied juveniles in particular. So I just want to make you aware of that. Namely, that an unaccompanied child, normally if someone's in removal proceedings, they're filing for asylum, their application gets heard by the immigration judge because they're in removal proceedings. In the case of an unaccompanied child, they actually are entitled to first file their asylum claim with USCIS, with the asylum office, which is a separate office that adjudicates affirmative asylum cases. And that is a theoretically non-adversarial interview with an officer who's asking them questions, not with an attorney who's trying to undercut their credibility and everything. And right now in asylum offices, there's an enormous wait of, I think, years in many cases to actually get an interview. So it can be beneficial to your client to be able to take advantage of this procedure and file first with the asylum office. It used to be that once a child, so that procedure for asylum is specific to unaccompanied children, right? However, the asylum office will accept the determination that the child was unaccompanied that was made at the border when they arrived. So even if the client has been released to a parent, technically they aren't really unaccompanied because they're now with a parent, or if they've turned 18 years old and so technically they're not really a child, nonetheless, the asylum office has said outright that they are still going to accept those cases. So that opens it up to more people. Also, for unaccompanied children, the 1-year deadline is waived too. So, and again, even if the child's since turned 18 or reunified with a parent, they can still take advantage of that. Another potential immigration remedy that sometimes we may see in these cases is a U visa. So a U visa is a special immigration visa and a pathway to permanent residency and citizenship for people who've been the victim of a certain crime, certain kind of serious crime in the U.S., have reported that or cooperated with authorities in the United States, and where a law enforcement agency, usually the DA's office or the police, will sign off on a certification confirming that your client was helpful to their investigation. And you also have to show that your client was substantially suffered some kind of substantial abuse because of this harm. So again, this is not something that we see a ton of for children who just arrived to the United States. So one would think, well, how much opportunity would they have had to get into some kind of situation where they fell victim to a crime? But it's something that we have seen, and it's something to keep in mind throughout the lifetime of working with your client, that should they fall victim to some crime in the future, that could then open up the possibility of them being eligible for a U visa. I've sadly had a couple of situations of clients, both teenage girls, that became victims of sexual assault in the United States, and then suddenly it raised this very unfortunate, obviously, for our clients, but this is the paradox of working in this kind of law, where the worse the thing is that happened, sometimes it entitles you to immigration benefits. So with U visas, when someone's granted a U visa, their relatives can usually qualify too. So if you're screening as an immigration lawyer for the first time, you obviously want to be screening not just your client, but making sure that their mom or dad in the United States, or a brother or sister, wasn't also the victim of a crime that could potentially qualify for the whole family for a U visa. So a T visa is kind of similar in that it has to do with being the victim of crime, in this case being the victim of trafficking. This is not going to apply in the typical scenario of a client who was brought to the U.S. by a smuggler because someone paid a smuggler to get them here. That in and of itself is not trafficking that would rise to the level of being the victim of human trafficking and qualifying for a T visa. But in the case of somebody who was brought to the U.S. to be forced into working, whether it was trafficking drugs over the border because you were forced by some gang, or young women who are brought to the U.S. to engage in forced prostitution, these are things that we have seen from time to time with juveniles, so it's possible that those things could come up. And then we talked also about family petitions. So if you're screening, again, a juvenile for the first time, do they have a mom or dad or a step-parent in the U.S. who happens to have legal status here and for whatever didn't bring them here through that, but could potentially file a petition to get them their status that way. So at the end of the day, in immigration court, if none of these other things are going to apply, and if you're not pursuing SIJ or some other form of relief, the last-ditch effort that you can do is file a PD request or prosecutorial discretion. And this is this concept that immigration, attorneys for ICE, just like criminal prosecutors, have the discretion to pursue some cases and not pursue others. And ICE has laid out in its memoranda a couple of years ago exactly what their enforcement priorities are. And so it's possible you can make the argument that in the case of a juvenile, they should not be a priority for deportation because, number one, they're very young, number two, they're pursuing their education. These are things that should lend ICE to exercise discretion to maybe close their case. If they have relatives, close ties to relatives in the U.S. who have legal status, all of these things could potentially support a PD request. On the other hand, I think kind of weighing strongly against that in these cases is the fact that the person entered the U.S. very, very recently, and that's something that ICE has said will lead them to think a person is a priority for deportation, and will lead them to deny a PD request. The last PD requests that I did were kind of before this big surge over the summer, and I had a few denied and a few granted. I haven't tried one since then. I kind of suspect that it would be hard unless you had kind of a really special situation. I don't know if anyone else out there has had more recent experiences than me, but just a thought. So any questions, concerns, thoughts about all of that stuff? Do we need to stop for lunch? It's 12:05. I don't know time. No, should we keep going?
Lunch.
What's that? So I've just got some more slides up here with just some kind of practical tips, etc., working with children. And, you know, some of it is pretty intuitive, and many of you, I'm sure, have worked with children in the past. But I don't know how much time we have to go through every single thing. What do you think? Yeah. Let's see. Well, what's that?
Do you think that a 45-minute lunch is sufficient?
Sure. Yeah. We'll just run. Yeah, we'll run through this and then we'll break for lunch. So thank you. Okay. So just some kind of basic for when you're working with a child client, and again, you'll have this all written out to read over at your leisure. But you're going to make sure to explain very clearly who you are, what you're doing, what the scope of your representation is, who you're representing, especially in the case of working with a child and with a guardian. And these clients are going to be, they've got their case in immigration court, they've got their case in family court, they're going to have their case with USCIS. It's hard for us to keep all that stuff straight sometimes, so just remember that your clients are kind of thrown into this mix for the first time, and are going to need you to explain to them very clearly at every step of the way exactly what's happening and why. You want to skip forward just some things? And just some things to think about, when you're interviewing a child, asking open-ended questions. You may need to interview them more than once before you get all of the information from them that you might need to represent them. And of course, if you're meeting with your child client for the first time, especially, you're going to want to interview them alone, even if they're on the younger side, because of obviously your duty of confidentiality to that client. And also to just keep in mind that they might you might have been contacted by the child's relative or caregiver who is responsible for them and cares about them and wants their case to be successful and is going to work with you. But that child might not have even known that person before they came to the United States, or they might not have seen them for many, many years. They might have been reunified with their mom, and maybe their mom left them in Honduras when your client was 5 years old. So the kind of family dynamic that exists in that household might not be what you would kind of typically expect, in other situations. We would, we are going to start using a retainer agreement that's kind of written in simple, child-friendly language. I know that different people and different law offices do this different ways. You might have your child client sign. You might also have the caregiver or next friend or parent sign on their behalf. Client communication, we've probably all seen this, but making sure that your client knows exactly how to get in touch with you. If you're in a situation where you're an English speaker and there's no one in your office that speaks Spanish, just to think about ahead of time, how exactly is your client going to reach you, and is there someone in your office who you could designate to receive calls from them to make sure that the information gets passed through to you? Just things to have in mind at that initial meeting with your client to set that out ahead of time. And then when you're doing your follow-up, sending out letters and things like that, making sure that it's in your client's language or that there's someone available to help them to understand it. Yeah.
What happens when they don't read or write?
Yeah.
It's not unusual for people who come and they went to first grade or they never went to school, that kind of thing.
Yeah, that's true. I mean, I think the best you can do there is just be aware of that, and then your primary way of communicating with them is probably not going to be through written communication. You're going to make sure to reach out to them by phone when you can. Get phone numbers for whoever you can. I don't know if anybody else does this, but so my clients, anytime I'm talking to them on the phone and I want to give them something to write down, they say, "Can you just text it to me?" And I say, "I'm on my office phone. No, I can't text you." But what I learned that you can do is send emails that go to people's phones. And in the stuff that we emailed out to you yesterday, there's like an instruction sheet on how to do that. You have to know this person's cell service provider. So what I do now is when I'm getting their phone number, I ask them who provides their cell service and whether they want me to send the messages. And then if I need to send a quick note, usually I can do that through email too. Everybody seems to have skipped over the home phones and just uses cells.
Sometimes it doesn't work.
Maybe that's the and then in addition to stuff like literacy and communication, sometimes we see stuff like school enrollment issues. I know that John works with his clients in Chester County to make sure that they can get into school, because we've seen sometimes school districts saying, "Oh, you need to have your parents in your home country sign this authorization to let you enroll in our school district," and that's not right. They shouldn't be doing that. But your clients might be coming to you with these kinds of questions, and might need a little extra help with that kind of stuff. Yeah.
When you have somebody who has come in and they only went to first or second grade and now they're 14 or 15, clearly they're not going to go to those grades. So do we establish contacts, or is there anybody establishing contacts with the school districts to see if we can place these children?
So in my case, by the time a child comes into my office, usually they've been here for a little while, and if they're in Philly, usually the Philadelphia School District, for one, is good at getting them enrolled. Go ahead, John.
In Chester County, we have migrant education,
Yeah.
and the children are enrolled immediately. And that's very important for dependency court, that the children don't go in front of a dependency court judge and not going to school. That will look really bad.
Yeah. So, and that's a good point. So migrant education, the migrant ed program is this statewide program, right, for migrant children. So how does somebody go about getting in touch with them?
The agency talk to a social worker, and they all know to get them enrolled at school through migrant education, but they don't. The guardian or whoever the child is with may not know about migrant education.
But if we get contacted by a guardian or a child and they aren't enrolled in school, can we put them in touch with migrant ed, and will migrant ed be able to immediately?
Yeah, because
that's a good idea.
It's state funded.
If they qualify, but to qualify for migrant ed, I mean, if you're here in the U.S. because you've migrated here.
Well, the kids we see are all a little bit older. They're all 16 or 17, and they all get put in 9th grade.
Yeah.
Regardless.
Go ahead, Mary.
The Welcoming Center and Education Law Center have helped us with some school registration issues as well.
A Welcoming Center.
Yeah.
Okay. Yeah, go ahead. Staff had a question? Yeah.
They all can just be enrolled in public schools. I mean, I've not seen a district. I mean, you see districts that give them a hard time.
Yeah.
They don't give them ESL classes.
Yeah.
But you should just tell your client, and you might make some phone calls, to go to the district and just enroll them.
Yeah.
Pilcop in Philadelphia, the Public Interest Law Center in Philadelphia, right? I know they've been working on some of these issues. They've got one of my SIJ kids.
Yeah.
And there's all types of issues, like Philadelphia doesn't want to issue notices in Spanish to the caregiver. There's lots of issues. But they just get they can just get enrolled. They're entitled to IEPs like any other child. And I know in Philly, if that child's not in school, there's two of the judges, you're not getting the family law order. Or you're going to be going back 3 and 4 times.
Right.
So they better be enrolled before you step through the door.
Yeah.
And going.
Go ahead, Judy.
Yeah, just a word about Migrant Ed, which is a terrific program, by the way. You're eligible to enroll them because they have a 90% graduation rate from high school. All these immigrant kids in Migrant Ed. But in order to be eligible, you have to have some connection with food.
Oh, right.
In general, I think you have to either work in a food-related industry, even in a warehouse. But there has to be a connection with food. So not every kid is eligible for Migrant Ed, but it's very possible that they are eligible for this program, and you should access it. It's all over the state, and it's not just school. They give these children tremendous peer supports, and these children succeed tremendously. So I just want to mention that. They have to have a connection with food.
Right, that's right. So, and then another quick point, actually, could you go back to that last slide, that I wanted to make is that you might want to get your client's ORR file. So there's records that are maintained when they're in the ORR shelter. And these consist of notes from caseworkers and clinicians that have met with your client, that have kind of taken their history when they've gone into care. And this is helpful because, you know, maybe your client doesn't open up to you right away about something that happened in their home country, but those notes might be in there and you might come across the information that way. So there's a pretty simple process online where you can get the forms to do that. And that brings us to the end with 45 minutes for lunch. But I just put up here a couple of kind of, if anybody's interested in literature or further reading on this topic, there's been a couple of really good books and documentaries that have come out. And then this practice resources list here, there's a couple of manuals and the like that are available online for pro bono attorneys that are working with juveniles specifically. So, you know, feel free to click through any of that stuff that's going to interest you there. Any other questions before we break for lunch? All right, cool. Thank you. If anyone is not staying, anybody who's not staying for the second half this afternoon, just again, make sure that you please fill out the evaluation form that we have, and you can just leave it up here on the table. Thanks.
Philly is great compared to Boston.
Yeah, there's
Were you advised?
Around the corner.